To order. Welcome to meeting number 90 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Pursuant to the order of reference of Monday, April 24, 2023, the committee is resuming consideration of Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. I'd like to welcome back our witnesses today from the Office of the Privacy Commissioner of Canada, Philippe Dufresne. Thank you for being back with us. Lara Eves, the Executive Director of Policy and Research and Parliamentary Affairs, and Michael McGuire, Director of Personal Information Protection and Electronic Documents Act. Thank you for being here again. I am very hopeful that we will have a good meeting and everything will work well. We're looking forward to hearing your remarks on Bill C-27. And so we will go to Mr. Dufresne for 5 minutes. Thank you, members of the committee and Mr. Chairman. I'm pleased to be back to assist the committee in its study of Bill C-27, the Digital Charter Implementation Act, which will enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. When I previously appeared before the committee 3 weeks ago, I delivered opening remarks about Bill C-27 and my 15 key recommendations to improve and strengthen the bill. Today, I want to briefly highlight and respond to the Minister of Innovation, Science and Industry's letter to the committee of October 3rd, 2023, and answer questions.
On the amendments being developed with respect to the proposed CPPA, where he seems prepared to agree with 4 of my office's 15 key recommendations, namely by explicitly recognizing privacy as a fundamental right, by strengthening the protection of children's privacy, by providing more flexibility for my office to use compliance agreements, including through the use of financial penalties, and by allowing greater cooperation between regulators. I also note and commend his statement of openness to further amendments following the study by this committee. I would like to take this opportunity to highlight other ways in which the bill should be strengthened and improved in order to better protect the fundamental privacy rights of Canadians, which are addressed in our remaining recommendations to the committee. I will briefly highlight 5 of our recommendations that stand out in particular in light of the Minister's letter, and would be happy to speak to all of our recommendations in the discussion that will follow. First, privacy impact assessments, or PIAs, should be legally required for high-risk activities, including AI and generative AI. This is critically important in the case of AI systems that could be making decisions that have major impacts on Canadians, including whether they get a job offer, qualify for a loan, pay a higher insurance premium, or are suspected of suspicious or unlawful behavior. While AIDA would require those responsible for AI systems to assess and mitigate the risks of harm of high-impact AI systems, the definition of harm in the bill does not include privacy. This means that there would be proactive risk assessments for non-privacy harms, but not for privacy harms. This is a significant gap, given that in a recent OECD report on generative AI, threats to privacy were among the top 3 AI risks, generative AI risks, recognized by G7 members. In my view, responsible AI must start with strong privacy protections, and this includes privacy impact assessments. Deuxièmement, le projet de loi ne prévoit pas de sanctions.
Second, the bill does not allow for fines for violations of the appropriate purposes provisions, which require organizations to only collect, use, and disclose personal information in a manner and for purposes that a reasonable person would consider appropriate in the circumstances. This omission would leave the federal private sector privacy law as a standout when compared with the European Union and the Quebec regime, which allow for the imposition of fines. If the goal is, as the Minister has indicated, to have a privacy law that includes tangible and effective tools to encourage compliance and respond to major violations of the law in appropriate circumstances, surely this shortcoming needs to be addressed for such a critical provision.
Remains the proposed addition of a new tribunal, which would become a fourth layer of review in the complaints process. As indicated in our submission to the committee, this would make the process longer and more expensive than the common models used internationally and in the provinces. This is why we've recommended two options to resolve this problem. The first option would be to have decisions of the proposed tribunal reviewed directly by the Federal Court of Appeal. And the second option would be to provide my office with the authority to issue fines and to have our decisions reviewable by the federal court without the need to create a new tribunal, which is the model that we most commonly see in other comparable jurisdictions. Fourth, the bill as drafted continues to allow the government to make exceptions to the law by way of regulations without the need to demonstrate that those exceptions are necessary. This needs to be corrected as it provides too much uncertainty for industry and for Canadians, and it could significantly reduce privacy protections without parliamentary oversight. Cinquièmement, et pour conclure,
Fifth and finally, the bill would limit the requirement for organizations to explain upon request the predictions, recommendations, or decisions that are being made about Canadians using AI to situations that have a significant impact on an individual at this crucial time in the development of AI, and given the privacy risks that have been recognized around the world, I would recommend more transparency in this area rather than less. With that, I would be happy to answer your questions. Thank you. Thank you, Mr. Dufresne. We will go first to Mr. Perkins.
Thank you, Mr. Chair, and thank you, Commissioner. The protection and safeguarding of an individual's personal information in the digital world and the artificial intelligence world we're evolving into, in my view, must be protected from the abuse of businesses and what they may intentionally or unintentionally do with that information. And after 8 years, this new Liberal privacy bill, which is flawed, introduced 18 months ago, sat for a year in the House before it was brought for debate. So I'd like to know, as Canada's Privacy Commissioner, as the guardian of privacy for individuals in this country, did the Liberal government consult and involve you in the development of this bill before it was introduced in June 2022?
On this question, Mr. Perkins, the bill was introduced before I was formally in place as Privacy Commissioner. The bill was actually introduced the day that the House of Commons approved my proposed appointment as Privacy Commissioner. So I was not consulted or involved, certainly before that, with respect to Bill C-27, because I wasn't the Commissioner. I have been since making recommendations.
Was your office consulted?
I know that there had been ongoing exchanges with my office and the department with respect to privacy matters. I don't know the extent of the details that would have been shared with my office prior to my arrival.
Perhaps you or your colleagues could tell me if you did share your concerns or your desires for what needed, or the offices of the Privacy Commissioner desire of what should be in this legislation to update it. What were the 4 or 5 key things that the office communicated before this bill was introduced in the House needed to be in this bill?
Well, my office made a number of recommendations on the predecessor bill to Bill C-27. And so one of them including recognizing privacy as a fundamental human right. There were some concerns were raised with some of the definitions, some of the ways appropriate purposes or the information was conveyed. So there was an extensive list of recommendation that was tabled by my predecessor that is on public record. And a number of those were considered and led to C-27. They're outstanding ones. In my submissions, I have highlighted 15 key recommendations, and in the annex, we made reference to previous recommendations that had been made.
So it appears, based on the fact that there are 15 things, some of which and many of which you say were on the public record, in the previous iteration of this bill that were ignored by the government in drafting this bill. Does the government ignore the Privacy Commissioner often, this Liberal government, on its recommendations on how to improve privacy law?
I view my role and the role of my office as promoting and protecting the fundamental privacy rights of Canadians and being an advisor to you as parliamentarians making the decisions. And so with this in mind, I've made 15 recommendations. I have communicated this, and my office has done that before I was commissioner with its views. Some were taken up by parliamentarians, by the government, some were not. And in this instance, as I've indicated in my opening remarks, I'm happy to see that at least until now, 4 of my 15 seem to have been taken up. I look forward and hope to be able to convince all of you, including the government, to take up the remaining.
So after the bill sat for a year, I presume the minister has said before the committee he finally reached out and had some discussions with you, or the department did. And 2 weeks ago, he came here and admitted his bill is very flawed in key fundamental areas, proposing 8 major amendments, which he has not shared with the committee so far after 2 demands by this committee to produce those documents. Has he shared drafts of those amendments with you?
No, he has not. I have the same information that you have, which is the letter that has been tabled with the committee.
So, as the guardian of privacy in Canada, if the Liberal minister was truly committed to having a bill that protected Canadians' privacy from the abuse of businesses in the massive data world that we live in, and wanted truly important and accurate legal wording to do what both you and your predecessors said on issues like fundamental rights being protected in Clause 5, do you not think a reasonable person who is truly committed to that would seek the advice of the independent experts about what's the best way to do that?
Well, I think that we do have significant advice that we can offer, and I certainly think that the ideal way would be for my office to be consulted as early as possible, as often as possible, with proposed privacy changes. Now, I understand that there are some issues about cabinet confidentiality as to what can and cannot be shared, but the topics that are being considered, the themes, the issues, I agree with you that if we're able to give input at the front end, there's a greater chance for
Draft regulations and input can always be shared publicly before going to cabinet to make sure that it's what is needed to achieve what it is without having to go back through the bureaucracy of cabinet. The fundamental right issue on Section 5, I don't buy that the preamble has any value since it's not part of the published statutes of Canada. The purpose section sets out the importance of the bill and what its goal is. So if the bill says a fundamental right or the protection of privacy is of equal value to an organization's ability to use that, isn't that putting the cart before the horse? Shouldn't an individual's privacy be more important than a business's ability to use it?
It should be, certainly, and this is why I've recommended this explicit recognition. As you know, up until now, it was described sometimes as a privacy interest or as a right. There was some more tepid language, I suppose, and my strong recommendation was we need to make this explicit. We need to recognize that it is quasi-constitutional, as courts have said, as the international community has said, so that in the purpose clause, and I recommended adding it in the preamble as well as in the purpose clause, but you're right, the purpose clause is the key. If you use the word fundamental right, you are sending a signal to courts, to decision makers, to myself, that even when you are balancing this with other elements such as the needs of organizations, which have to be considered, we have to have innovation at the same time as we have. But if there is a clear conflict, one should prevail, and it is the fundamental right that should prevail. This is why it's so important that this is enshrined in the law, and I was encouraged by the statement of the minister that this is now the intent, certainly something I've been advocating for since day one.
Thank you.
Merci beaucoup, Monsieur Perkins. Monsieur Dufresne, Monsieur Sorbara.
Mr. Sorbara, please.
And welcome, Commissioner. Commissioner, on October 3rd, just a couple, 2 or 3 weeks ago, I guess it was, You provided keynote remarks at the Big Data and Analytics Montreal Summit 2023. I've had a chance to go through your remarks. And in one of the sections entitled Law Reform and Regulation and the Regulation of AI in Canada, you reference changes to CPPA and also to the AIDA. And you also comment about being encouraged by the introduction of the bill. And I'll use my own words, the tone and direction of the bill. And one of the comments you make is about the fundamental protection, the protection of fundamental privacy rights. So in terms of reading your speech and going over it, on C27, the direction of the bill, you are encouraged.
I've called it a step in the right direction, so I am encouraged. I see a possibility for further improvements, and those are the 15 recommendations that I am making. But I have said, and it is a step in the right direction.
And on these are new terms, new lexicons that are being introduced into our vocabulary on regenerative IA, if I can use that term, generative IA. How, if you had to contextualize or risk, and you use the word risk quite a bit, on the risk to privacy, where would you rate that as? Right.
Well, risks to privacy are significant in the context of generative AI. That's certainly my view. It's the view of the G7 minister. I've pointed to a recent report of the OECD in September of this year where the OECD canvassed all of the G7 digital and tech ministers about the top risks of AI, not just the risks, the top benefits as well, because there are benefits in terms of productivity and so on. And the top 3 risks in this report included privacy. So the first one was disinformation, misinformation. There were risks to copyright. Risk to privacy was third, and you had risks of exaggerated biases and discrimination. So those are the top risks. I would agree with that categorization.
Thank you for that color, because this bill and this committee is going to be very learning for myself. And would you state that Canada, with this legislation, is a first mover?
Well, IDA, with IDA, Canada has the opportunity to be the first. There is legislation in Europe that is moving forward, and that is something that we've pointed out in our submission, indeed, on C27. That this is a positive step. Parliament needs to get it right, and what I'm highlighting in the context of AI in particular is that the ADA bill would bring in significant proactive risk mitigation measures to deal with harms, to deal with bias. This is good. These are important measures. But they leave out the proactive steps for privacy, which is in the top 3 risks, which is why I'm insisting on having privacy impact assessment as a mandatory obligation in the privacy bill to close this gap.
And if I understand this, and I apologize if I don't understand it, you'll have to forgive me for that, and that is why it's important to list privacy as a fundamental right.
Listing privacy as a fundamental right is certainly part of it, and certainly sends the interpretive message about how this is to be treated. Having privacy impact assessment as an explicit legal requirement is helpful to organizations because they know what they have to do. We can provide guidance through regulation or through my office so that industry gets this certainty, so that they can know, well, they're investing resources in doing this. Why are they doing it? To protect privacy, but also because there is legislative backing.
Okay. When you mention industry, I take it one step back. I think of just the individual having a right to their privacy, to whatever degree, not just industry, but also the signal to industry about how they should treat the individual's privacy. And I tie that back to personal responsibility of the individual, but also personal responsibility tied into industry. Your comments on trans-border data flows, because we obviously work and are connected through an integrated world, as we see on a daily basis, sometimes for good and quite unfortunately sometimes for not. How does the trans-border data flows, in your view, and how should we be thinking about that?
This is an issue that the international community is grappling with. In C27, you have provision about making sure that other countries are providing similar levels of protection through contracts. Other regimes have more detailed rules about this, looking at the GDPR, which has the adequacy regime. So there's a number of models for that. What's important is making sure that the privacy of Canadians is protected with the data leaves Canada.
So, as somewhat of an accountant, but a more finance person, in accounting there's rules-based and principles-based. On this type of legislation, is it better to go rules-based or principles-based?
Well, it's principles-based because it needs to be technology neutral. It has to be legislation that will stand the test of time. It's 20 years old. Public Privacy Act in the public sector is even older. So we need this legislation to keep up with fast-moving technology. So we're talking about principles, but we also need in legislation some specific obligations so that organizations and Canadians know the rights. For instance, we take the safety of travelers in airplanes very seriously. We have pre-departure safety checks all the time to make sure that this is done, and this is done proactively, not after the fact. I see privacy impact assessments as being the same thing, making sure that on the front end, you're looking at privacy, you're treating it as a fundamental right, you're mitigating those risks, not only after the fact.
Thank you, sir.
Merci beaucoup, Monsieur Sorbara. Monsieur Lemire, pour ces...
Thank you, Mr. Lemire, please. Thank you, Mr. Dufresne, for being here and for your recommendations that are constructive, of course. When you were last here before the committee, you said that the preamble needed to be strengthened so that privacy was recognized as a fundamental right, and that this should be in all aspects of the law. But as my colleague from the Conservative Party has pointed out, this does not have the force of law. Yes, my recommendation is about the preamble that refers to international instruments. So it's a step in the right direction, because when things are ambiguous, we can look at the preamble. It isn't a legal provision, but we also recommended amending Section 5. In the Google case, we made that recommendation, and the appeal court indicated clearly that it was in the purposes of the bill that we really saw the thrust that was wanted. So do you feel that privacy as a fundamental right, if it is defined as such, puts us in a leadership role? Does that make us a leader international? Yes, it's explicit. In Europe, for example, and in Quebec, in those systems, and in all of the international meetings that I've attended, there is consensus on that. That is, privacy needs to be treated as a fundamental right. So it's important internationally, but in Canada, to protect people's privacy rights. It's part of our freedoms, and it supports other rights as well, our election rights, our right to equality, and so on. So it's essential that privacy be recognized as such and that there be no ambiguity. The minister has supported some of your recommendations on privacy, but you had 15 recommendations in all. So are there other recommendations that should be emphasized and that the minister hasn't adopted? Yes, I have listed the 4 that the minister has indicated will be adopted. And you mentioned that there were 15. And I refer here to 5 in particular. The first is to have the assessments for high-risk activities when there is new technology, for example, that can have an impact, like artificial intelligence, that be included for the PIAs. That it seems to be contradictory if this is one of the 3 greatest risks that we don't account for these privacy harms. Second, I would call for greater transparency for decisions made about artificial intelligence. Right now, explanations are called for, but only for decisions that are considered to have a significant impact. And I feel that it should be regardless of impact, those questions and that can be raised, and the transparency is necessary. People are concerned. We know that artificial intelligence has major benefits, but it also has impacts on privacy. We need to be able to answer those concerns, and this would contribute. I talked also about the issue of monetary penalties. I think that those need to be imposed, and that's why I emphasize this. I think that there needs to be this kind of motivation for some entities, but it shouldn't be just for the most significant violations. We need to emphasize these penalties with respect to legitimate purposes. Then we know that the government has significant regulatory authorities that may be too broad. The government, under regulation, can even can create exceptions, and this may not be warranted. There is also the idea of creating the tribunal, and this will create extra costs. It's an extra level of review, and this isn't the model that has been adopted in Quebec and in Europe and elsewhere. So my recommendation is that if the tribunal is created, it should be a direct appeal to that level. But another possibility would be, as is done elsewhere, my office could be given authority to review the decisions and be the appeal level. Very quickly, would you be open to the idea of having penalties that are non-monetary? Could there be other kinds of penalties? Yes, under the bill, there could be orders that are issued by my office rather than fines. Under the bill, the regulations would indicate the factors, the approach, the diligence, all those aspects. If a company carries out its work diligently and so on, then that is important. There are situations where an organization where this could apply. I think that the fines are high enough, though. I think those two tools are quite important. Also, there need to be persuasive powers during negotiations so that we can have agreements, the compliance agreements. We want organizations to make the right decisions before rather than after. Thank you. Thank you, Mr. Lemire. Mr. Massey.
Thank you, Mr. Chair, and thank you for being here. And sorry if I asked a question a second time. We had technical problems on this end over here, so I missed some of the testimony and so forth. The first thing I want to clarify to make sure, and I did ask this of officials, the Competition Bureau recently basically had the tribunal issue a penalty on the Competition Bureau for doing its job, $9 million. For it doing what it thought was the right thing and the due diligence of looking at the takeover of Shaw from Rogers. And I've been assured that this can't happen in this situation if such tribunal were to be created. Is that accurate? And wanted to know if you had had that same opinion.
Well, my understanding of the situation involving the Competition Bureau is that the tribunal made an order for costs, for legal costs, and for the expenditures in the context of that litigation. And so that is an ability that courts have in litigation. That is an ability that I understand the tribunal would have, I believe there is, and my colleagues can confirm, but there is a proposed provision that the tribunal be able to award costs. That would be the proposed tribunal in this instance.
Okay, so I mean, here's this is my problem with the government on this, and I'm not even sure if they're serious about this bill anymore, because not only we have a hard time getting the amendments and the drama that went around that, and maybe we'll get the amendments for your department tomorrow if there's compliance, but that's a direct thing that I asked, and hopefully we can have our own researchers and analysts kind of test that out, because it almost makes it a moot point in many respects for the Competition Bureau and the independence of a public entity to be able to challenge the conglomerates and the powers that be to actually go forward. In fact, it's the $9 million is a drop in the bucket, if that, for Rogers, but it's a squeeze on the Competition Bureau and clearly puts a chill down the spine of basically anybody that's interested in consumer rights in Canada, that you can be basically bullied into the corner by a legal process. So that's good to know, because I have some reservations about the tribunal to begin with. And if that's the case, this is much more abhorrent. With regards to your 15 recommendations, could we walk through the 5 that the minister has agreed to in terms of those recommendations? I want to make sure it's clear for those that are here. Can you identify which 15 in what you've submitted here today are the ones that the minister has agreed to?
Certainly, and just on the previous question, it is Section 20 of the Tribunal Act that would give the ability to award costs in accordance to the tribunal's rules. In terms of the recommendations that the minister has signaled agreement with, the first is the recognition of privacy as a fundamental right, and in the annex of his letter, as I understand it, it mirrors my recommendation in the sense of recognizing it in the preamble and recognizing it in the purpose provision. So that's one.
Number one. Yep.
Number one. The second is recognizing a strengthened protection for children's privacy. This is one where I had recommended amending the preamble. On this, the minister agrees and goes further and proposes to amend Section 12 on the appropriate purposes to include children's privacy there. I am supportive of that additional recommendation.
So that's number 2.
So that's number 2. Number 3 is to provide more flexibility for my office. Sorry.
So it's I just want to, without going into details, it'd be 1, 2, 3, 4, 5. Is that kind of how you stacked your document to us?
I was listing them in order that the minister had them. If you prefer, I can give you the numbers in my recommendation. So, yes, okay, sorry. So number 1, my number 1 recommendation, fundamental right, has been accepted. Number 2 recommendation on children's privacy has been accepted. And the recommendation on number 12, provide greater flexibility in the use of voluntary compliance agreements to help resolve matter. And the 15th is not explicitly in the annex, but I take it from the minister's testimony and from the overall mention in his letter that he is open to coordination and cooperation between regulators, which is number 15. So I understand.
Possible 4.
Right.
If we get that, but as my previous question about the tribunal, blows that kind of potential, whether we have to really figure that out, because I was told that it wasn't the case,
right? And
now it is. So number 4, and so is number 5 in here too? Is it matches up with any of your recommendations?
So I've identified 4. So those are the 4. Number 1, number 2, number 12, number 15. The minister did allude to other themes in his letter. I think he talked about the exceptions, but was not as definitive.
Yeah, no, okay. And we only know that there's going to be 3 amendments coming forth. So it'll be interesting, because that doesn't even match up right there. I'm going to be running out of time soon, so I'm conscious of that. Is there any possibility that we can get from you a ranking of your other recommendations? Like, so I'm going to go through this, do the due diligence, but I guess what I'm curious as to the privacy commissioner in your office, where there is, high level degree of exposure or complications that need to be fixed, in your opinion, in your professional opinion, and then maybe other ones that are less costly to privacy. So I'm looking at almost like a ranking of some sort that we could weed our way through this, especially those that are coming forward.
Well, and I've given that to you in today in my opening statement, I've listed 5 outstanding ones that the minister has not yet agreed to. So those would be the top priority, starting with the notion of a privacy impact assessment for generative AI. To me, that is a major shortcoming. And if you look at ADA, and if you look at indeed the minister's proposed amendments to ADA, you see a lot of discussion about risk mitigation, identifying risk, managing risk. This is absolutely essential and critical, but we need to do this for privacy as well as for non-privacy harms. So that I'm insisting on this very much. The other important recommendation to I would say is in the top priority is making sure that fines are available for violation of the appropriate purposes provision. This is violation of Section 12. This is the key central provision. This is the heart of the bill in a way. And there are no fines for that. And so that, in my view, should be corrected. It's easily corrected by adding that to the list of the breaches. Other comparable legislations, like Quebec, for instance, they simply say a violation of the law. So the whole law is there. It's all covered. This approach lists offenses, and in C11, there were more omissions. It's been corrected to some extent, but it needs to be corrected further. I talked about algorithmic transparency, an important element, especially at this time in AI. And again, we can manage that and providing guidance with industry so that it's something that's workable. But I think Canadians need to understand what is going on with their data, how decisions are made about them. And if we limit it to matters that have significant impact, we're creating debates and we're limiting that transparency that Canadians deserve. And so that is.
I'm out of time, but yeah. So just a summary was here's what we've done. We have a bill here where we have the capability of the private and bad actors suing your commission, just like the Competition Bureau, and we've limited our fines and penalties on bad actors. Perfect scenario. Thank you, Mr. Chair.
Thank you, Mr. Massé. And before going to Mr. Williams, if you allow, colleagues, I'll just grant myself a minute for one quick question to Mr. Dufresne. Oui, je sais. Unanimous consent. Juste une petite question. Monsieur...
I just have a short question for you, Mr. Dufresne. If I asked you to play devil's advocate, what would be the best arguments in favor of the tribunal? Well, the best arguments, and this has been part of public debate, there is concern about giving too much responsibility and powers to one entity, that is my office. So if we have the power to issue orders and significant penalties, should we also have these other powers? So that's the concern. I think that we can address that concern by saying this is the model used in Quebec and internationally. There should be a careful process. It should be a different process than we use for the penalties. So in the bill, it would have a different process. And there is a new mechanism, which would be an inquiry process that provides for the parties to be heard. And this is the model, as I said, that has been used in in Britain, and elsewhere in Europe, in France, in Quebec. So when it comes to orders and fines, then it is a more formal process. We have the procedural basis there, and it wouldn't be a problem to go right to the appeal court from there, because the Supreme Court has ruled that it is acceptable to have one entity doing those various things. I think that it comes from a concern about concentration of powers. Thank you. Mr. Williams.
Thank you, Mr. Chair. Thank you, Privacy Commissioner. I know there's been a lot of comments today about what the minister said and what's coming forth. I want to make it very clear to those listening at home, this is a bill that's very important because for the first time in 20-some years, it's dealing with what is the most amount of data that individuals have ever had out in the open, including our children. And we're dealing with the data and, of course, the second section and AI. And it's not up to the minister to approve certain amendments or to decide what he wants to give us. It's up to this committee and then the House of Commons to determine how this bill, if adequate, will go forth to protect Canadians. So I want to make that very clear. We feel, as the bill is presented right now, that this government has not taken privacy seriously, not listed privacy as a fundamental right into the purpose clause statement of this bill, as we've had other sub-regions of country like Quebec have already done. We certainly feel that I want to speak today on a certain portion that this bill already gives more power to business than it does individuals, and to a section I think that you've identified called legitimate interests. So, Commissioner, I'd like you to define, in your own words, for the public and for people listening, what legitimate interests are. I know you have a legal background, and I know it's your fourth recommendation, and you stated, and I want you to explain, how does this drafted bill continue to allow the government to make exceptions to the law by way of regulations without the need to demonstrate that those exceptions are necessary?
Thank you for the question. And so the bill provides for some exceptions to the ordinary obligation to have consent and knowledge. So the bill provides exceptions in situations where it is linked and necessary for business operations. There's a carve-out for activities that those should not be for the purpose of influencing the individuals. And so the bill recognized that there may be some instances where businesses would need the information and it's not practical, but to obtain consent or to advise individuals of it. But the conditions for that is that a reasonable person would expect the collection or use for such an activity. Where I have a concern is that the bill provides a list of activities that could be considered business activities in the Act, and some of them are all, the first one is an activity that's necessary to provide a product or service that the individual has requested for the organization. So there is that element of necessity. The second example is an activity that's necessary for the organization's information system or network security. Again, necessity is there. The third is an activity that is necessary for the safety of a product or for the organization. So this element of necessity is crucial because that's what comes and justifies the fact that you're going to get consent. But the fourth, and this is at section 18(2)(d), says any other prescribed activity. So it means that the government can add anything in there without a requirement of necessity. So my recommendation is that this needs to be limited to say any other prescribed necessary activity, or make that clear that the government is always limited by that necessity test.
How hard would it be for you in your office to disprove claims of the collection or use of Canadians' data without consent under the legitimate business interest exemption as it's currently written?
Well, the concern that I have with this provision is not so much that our ability to prove or disprove something or to make a finding on something. It's that if you add an activity in this list, I am bound by that list. The courts are bound by that. So if you add an activity in there that is not necessary, that becomes an unnecessary exception to the rule of consent. And it's one that I would have to apply because I am certainly bound by the law and I will apply the law, as will courts. And so that means that because of this section, there is a risk, there's a possibility, and I'm not suggesting that that's the intention of the government to do so, but the law would allow it for the government to carve out something that is unnecessary. And so I think that should be reduced and limited to make sure that the exceptions that we have to this fundamental right to privacy are necessary exceptions.
Commissioner, yes or no, are you comfortable that Bill C-27, not defining legitimate business interests as it currently stands, allows the government to make lists of activities and regulations that would give balance to businesses over the privacy of individuals?
Well, what I'm saying is this is a problematic grant of authority to the government to carve out parts of the Act.
So are you comfortable with how it's written right now?
This
yes
section,
no?
I'm not comfortable with it. I'm recommending it be modified so that that authority be more narrow. And as indicated in my submission, there's another section elsewhere in the Act highlighted in my submission where, again, a whole activity can be removed altogether from the bill. So then the bill wouldn't apply at all. and this is something that should be corrected to limit its scope.
Thank you, sir.
Merci beaucoup. Je passerai la parole à Monsieur Turnbull.
Thank you. And we will go now to Mr. Turnbull.
For being here. Appreciate your testimony today. Always found you earlier when I had the chance to work with you in your office to be very helpful and very good at communicating when I was on PROC. So I thank you for that. And so appreciate your expertise, and I think you bring a lot to this conversation that's very important. We want to strengthen this bill and continue to see it get stronger and stronger throughout this collaborative, hopefully what's a collaborative working relationship for all of us. Certainly for me, one of the top concerns I have is the rights of children. And I know that you've spoken to this, written about this. Many children today, as we know, are immersed in the digital world. I can speak from experience. My 11-year-old daughter hides devices and on many apps and downloading things, and there's pop-ups, and she sometimes purchases things. There's data being gathered of her preferences, and so this really concerns me. I think it concerns a lot of Canadians with regards to children's data and protecting children's right to privacy. So I wanted to ask you, are there currently laws in Canada that help protect children's privacy? So that's the online. So that's the first question. I'll have another one about this in just a second.
Right. Well, the current privacy legislation, we've provided guidance in terms of how to obtain meaningful consent, and in that we talk about some of the things that should be looked at in context of children. We've recently, my federal, provincial, territorial colleagues and we've recently issued a statement, a resolution on protecting young persons' privacy, giving examples of things that should be done and should not be done with the data of children, not nudging them to make bad decisions, recognizing that they are more vulnerable. And so we can interpret the law to some extent to protect children, but we need to do more. And this bill has started to do so, because there is now a recognition in the initial version of the bill, and I give credit to Minister Champagne on that. This was in the original C-27 bill as tabled, the recognition that the information of minors will be deemed sensitive information. And so that has impacts in a number of areas in terms of disposal rights and so on. And so we took that, and in our recommendations recommended to go even further than that, to highlight the best interest of the child in the preamble of the bill, so that if there is doubt in terms of interpretation, you can look at that. The minister has signaled his agreement with that and has suggested going further to include the special situation of children in Section 12 to interpret appropriate purposes. And so that is a further improvement that I would certainly support. We see comments like that in the European context with the recital to the GDPR, recital 38, highlighting that children deserve special protection. UNICEF has said that. We know that our kids are digital citizens. They're spending time online for all aspects of their lives, including school. We've certainly seen it more in the pandemic. And so it's important that the legislation protect them appropriately and protect them as children. So we need to protect the best interests of the child, and we need children to be able to be children in that world and to be protected and to not suffer consequences later on when they're adults for things that they would have done online. So there's improvements there, and I certainly support them.
So when you say go further, I'm kind of interested, because I think, it's always a balancing act. I think later maybe we'll have a question about, supporting innovation and balancing privacy rights is, as we know, with any of these tough issues, and emerging technologies, it's a balancing act. But I'm sort of interested, is there, in your view, should there be an extra set of fines or penalties for violations of the sensitive information that's collected on children?
Well, I'm recommending that the sensitivity of information is an element that's going to be considered in the bill. It's going to be considered. I have to consider that in how I conduct myself. And sensitivity of information, it impacts form of consent. It impacts the retention and periods. It impacts the security safeguards. And so certainly something to be considered and should be relevant. The proposal by the minister that I support to add the special situation of children to the purpose clause, section 12, is important. And I would add to that my recommendation today to make sure that if you breach section 12 and you breach the appropriate purposes, including by treating children's information inappropriately, that there be available fines for that. But beyond that, with respect to children, I'm not suggesting more than what has been suggested by the recent proposals by the minister.
Thank you. I appreciate that. So the other thing that comes up for me often is thinking about how companies often collect information. I've heard stories of Tim Hortons collecting location information on users of their app, which I think is concerning for many Canadians to be sort of tracked and how that information is going to be used. How could Bill C-27 prevent that from happening in the future?
Well, Bill C-27 needs to prevent that to the same extent that the current law prevents that. And as you know, this was a matter that my office investigated, and we made findings that Tim Hortons had breached privacy law by collecting more information than they needed, by not being transparent about what was being done with that information. So we see these situations, and we've made some recommendations and some findings. Where C-27 will help more than the current law is it will provide for obligations more explicit in terms of explaining consent, making consent something that is explained in a meaningful way for individuals to understand, but also the possibility that my office can issue orders. And the possibility of fines. I do believe now in the Tim Hortons situation, the organization followed the recommendation. In the Home Depot decision that I issued last year, finding a breach of privacy, the organization agreed with the recommendation. But that's not always going to be the case. And so there needs to be the ability to have these enforcement tools, hopefully not using them, but reaching those results faster in a proactive way.
What would the consequences be?
Mr. Turnbull.
Am I out of time?
Yes.
Oh, sorry, Chair.
No worries.
Thank you very much.
Je passerai la parole à Monsieur Lemire.
We will go now to Mr. Lemire. Thank you. Thank you, Mr. Chairman. I would like to hear from you, Mr. Dufresne, about the rapid advances in technology that are threatening our privacy. Do you foresee the implementation of kind of a wall so that data can be set aside to see if there are privacy concerns before they are used? Yes, I think this is a good practice. If we have a sandbox with respect to artificial intelligence, this allows industry to be able to test in a secure environment what the effects would be. Of course, they need to have resources to do that. And I think that there are provisions here that don't go that far, but they would allow us to give advice to industry. And I think this would help SMEs in particular, but the resources would need to be provided. There is also a provision for a code of ethics. So these are proactive, preventive practices. I have made recommendations. We need management practices to be put in place. So the investments have to be made upfront. But what we've heard from industry, there's an OECD report that consulted heads of corporate CEOs and so on, and the finding was that it was hard to figure out where to invest the resources and what the result would be and so on. So if we have the sandbox, then we need the resources. If there is a legal opinion, then this can be helpful. We can tell companies this is the right thing to do, but if it is in the bill, that would be helpful too. There is the certification process that could help corporations decide to adopt these practices and then get certification that shows their good faith and due diligence. And so it's an incentive to help them move in the right direction. We want to encourage Canada to position itself well. We need to reward those that act properly. So I think the two things go together. So we want to promote and protect. We want to avoid just punishing people after the fact if they don't do the right thing. Thank you. Thank you, Mr. Lemire. Mr. Massey.
Thank you, Mr. Chair. Just curious as to how you think the Canadian model that's being proposed here measures to the American model, since we're so tied with trade and many of the companies are subsidiaries one side or the other. Just curious if you have discussions in the United States with, I know they don't have a privacy commission, but they have some other elements. So perhaps your thoughts on that.
Well, we do have lots of discussions, in particular with the FTC in the U.S., which has jurisdiction for antitrust, which is with the equivalent of our competition law bureau, but also through that deals with privacy. There's no national privacy legislation in the U.S. at the moment. There's proposals before Congress on this, but it's not moving forward. California has its own model, and they have some innovative mechanisms there, certainly, to protect privacy. But nationally, there is no equivalent with the U.S. So we are in close discussions with those colleagues about AI. In fact, when I was in Japan last June, we issued a statement on generative AI. This was all the G7 commissioners for privacy, and then for the U.S., that was the FTC. And in that, we noted a few things. We noted, one, that there are laws that apply to AI for privacy. They need to be applied. They need to be respected. And it also highlighted that we need to have privacy impact assessments. We need to have a culture of privacy when we're dealing with generative AI, because in many cases it is built on personal information. So there's lots of exchanges that are going on in that space. But I think the consensus is making sure that our citizens are aware that, yes, AI is moving at a fast pace. We have privacy laws to protect citizens.
Yeah, there's nothing moving in the United States in Congress right now. They can't even agree on a lunch, let alone a speaker. So there's not going to be a lot of movement there. And I guess what I worry about, though, in terms of a larger, broader picture, is the corporate influence on the United States and the legislatures with some of the lobbying that can take place. We have a containment factor to a certain degree here, aside from persons being able to get some supports later on, but they're nothing near what the United States has. So just want to keep that in mind as we go forward with the United States. And you mentioned Japan. And then just real quickly before I lose my time here is what about Europe? What's your connections there and what's happening?
Yeah, so we're working very closely with Europe, with the G7, with the community worldwide. I was at a meeting of the Global Privacy Assembly just last week talking about ethical uses of AI and highlighting the fact that we need proactive, strong privacy protections. But going back to the collaboration with the G7, again, we issued the statement on AI, working very closely together. I was pleased to see this statement cited in the voluntary code issued by the Department of Industry to deal with AI, and reminding organizations that we currently have laws that apply and they have to be respected. But in this new bill, That's why I am highlighting that we absolutely need to make sure that protective, proactive privacy assessments are there and that they are a legal obligation. We've seen it many times that right now in the public sector, there's no obligation for privacy impact assessments. It's in a policy of Treasury Board. Often we'll see those impact assessments done. If they're done, they'll be done later. And so it's important to have that legal obligation. But I can tell you that the international community is very much focused on AI, as are the G7 ministers. And as you say, the debates are going on in the U.S., but certainly what is being highlighted and noted is that you cannot separate privacy from AI. So to protect AI, to deal with AI, to have guardrails, you need strong privacy protections.
Merci beaucoup, Monsieur Généreux.
Thank you, Mr. Généreux, please. Thank you, Mr. Chairman. And thank you to our witnesses, Mr. Dufresne. This Liberal bill on privacy was introduced 18 months ago. It stayed without any action for a year. So from what you've said, I understand that you personally have not had a chance to comment. You haven't been there as commissioner very long. Perhaps your office has been. But how is it that you are telling us today that you provided 15 recommendations? The minister has proposed 8 amendments, but you haven't seen them. And you are being questioned today about a bill that is far from being finalized. So we're going to be debating this bill further. Can you give us an opinion on the future wording of the amendments that the Liberals will introduce so that we will have your feedback about this bill, which clearly isn't in its final form? And here's my other question. Why do you think the minister adopted only half or even less than half of your recommendations? Why don't you think he accepted more of them? Well, regarding your second question, I think you would have to ask the minister why he accepted certain recommendations but not others. But he certainly showed openness in his letter to consider others during the committee's proceedings. I can't speculate further than that. As far as providing additional advice or comments, I certainly will be as helpful as I can. I can come back to answer further questions during your deliberations. I'd be happy to. Well, we keep hearing that this bill is one of the most important ones that the House will consider, but yet, though it deals with such an essential aspect of Canadians' life, that is privacy, we still today, despite discussing the bill for several meetings, we still don't have the wording of the amendments. We've had this letter, but as you know, words are very important. You mentioned your first recommendation about privacy being a fundamental right, and it would perhaps be in the preamble, but not elsewhere. So we still don't have a final wording. We don't have final wording for the amendments. So we want to have your opinion throughout the process. What is your opinion? Well, I have seen what is contained in the letter, but we will have to see the wording of the amendments when they actually come out. I can also give you my opinion about what is not in the letter. The minister has said, well, these are the things that we are prepared to accept, probably. So certainly some of those are in line with my recommendations. The idea of having privacy considered a fundamental right, protection for children, the compliance agreements, and I haven't seen the details of the amendments, and then the cooperation between regulatory bodies. We talked about the FTC in the U.S. Well, my office can cooperate with the FTC, and we have done so in its investigations, but we cannot do so with the Competition Bureau in Canada. Why can we cooperate with foreign bodies but not our own counterpart? So we've got artificial intelligence, but we've also got overlap with other rights as well. It can be helpful for everyone, citizens and industry, to cooperate. But there are 8 other recommendations that I have made, and the minister has not said they would be acceptable. I can share those recommendations. There is nothing on the table but them. Well, so there are 8 that the minister has not said would be implemented. Which of those do you feel are key? Well, certainly my recommendation number 6 about the assessment of the privacy impact assessments, because that is fundamental and there are considerable risks to privacy. You are talking about data collection. Yes, the use of that data, the retention, the saving, the appropriate purposes, all aspects of the impacts on privacy, all of that has to be taken into account when we're using AI. We can have a program to manage privacy interests, but we need to be able to assess the risks and the means taken to manage those risks. There's the issue of monetary penalties if data is used inappropriately. So all of the recommendations are listed there. You have the 15, and the ones that haven't been accepted by the minister, those are the ones that I would put forward. Thank you.
Commissioner. Canada's privacy laws, the legislation is 20 years old. During that time, we had Facebook come about, we had the iPhone released, we had social media become prevalent. So it's actually very alarming that we haven't updated it in 20 years. I come from that generation that was very young when, for example, Facebook was released. And I think individuals, I'm not in that category, by the way, I was very careful, but I think individuals posted information that perhaps they did not want to, especially looking at it in hindsight. We know that the new legislation, there's an expansion of the personal information that individuals can request that it be disposed of. What do current laws cover, and how does the bill strengthen the ability of Canadians to have their personal information disposed of?
Well, one of the issues on that point in the bill is that it allows a greater right to disposal of information. So that's a positive thing. And in particular, vis-a-vis children, it creates a stronger right to disposal. So the example you give, you post something when you're a minor, and then when you're an adult, you want it taken down. So there's stronger protection there. One of the things that I'm recommending, in fact, is making it even stronger even for adults. Because right now, there's an exception in the bill that says that the organization does not need to dispose of your information if they're keeping it in accordance with the retention policy and they've informed you of that retention policy. That doesn't apply to minors, but it applies to adults. And so we recommend that be removed as an exception because we feel that is a broad exception. So the organization tells you what their retention policy, and then you don't have the right to the disposal of that information. And so we haven't seen that type of condition in international models, and I feel that we should provide a greater right to disposal in this section.
So how would the process work itself? I know what websites I use, for example, but maybe perhaps I don't remember all of them. So how would an individual that wants to dispose of some of that information even find out where their information is being stored? And what if the company is no longer, what if it's defunct now?
Well, so there are obligations for organizations to proactively prepare privacy management programs and to share some information about that. If it's information online, the idea would be that you would see it online, but there are obligations in an organization making it as useful. Obviously, if organizations see information about themselves and they have challenges finding where it is, they can reach out to my office, or so we can assist and seeing what's going on there. But that touches upon a point of transparency, making sure that Canadians can understand what's going on, because not everyone is an expert in technology, yet we are living lives very much digital. And understanding what's going on, certainly with respect to AI, the notion of algorithmic decision makers, and we hear a lot of comments about that, and we have our surveys of Canadians, and we see that Canadians are concerned about the protection of their privacy. And I think part of the solution to that is communication, is making sure Canadians can understand what's going on, what are the institutions that protect you, what are your rights, what is being done with your information. Sometimes we can have an impression that's worse than reality. So that's why I'm recommending that there be strong transparency. So in the bill right now, organizations who make AI decisions about Canadians, that if it has a significant impact, they have to proactively explain the general processes of those decisions. And they also have to answer questions if you get a request. But that's only if that decision has a significant impact on Canadians. My recommendation is that if a Canadian asks for an explanation, they should receive the explanation. Even if it doesn't have a significant impact on them, it still has an impact on them. They want to know what's going on. I think that's beneficial for Canadians to understand what's being done with their data.
Great, thank you. So my colleague, Mr. Turnbull, asked the example of Tim Hortons, how the app was tracking the data. The example that I want to reference is this happens all the time. I'm in a room. There might be a device in that room, and I'm talking about a particular product with my friend. And I'll go into the other room where my computer is. I'll go online and I'll see an ad for that very product, and it can be a very peculiar product at times. So you wouldn't normally expect to see that ad appear. So what is this bill doing to protect Canadians from that? What penalties can companies face if they don't comply with these new laws?
Right. Well, that raises the whole issue about consenting to being tracked, privacy by default. What are organizations doing? What are they telling you? What those default provisions are? In my view, the default provision should be privacy protective. Certainly, if you're dealing with minors, and so making sure that you have these protections in place, that you understand what they are, that you can ask. Again, that transparency, the perfect example that you're giving. You see this, you want to know why am I receiving this? Being able to get that explanation, being able to understand, have you consented to this, and how is your consent interpreted? And this is what we've seen in some of the investigations that my office has done, whether it's Tim Hortons or Home Depot or more recently Canada Post, is a sense that Canadians don't know what's being done with their information, and sometimes there's a disconnect between what organizations believe Canadians agree to and understand and what actually is going on. And so that transparency, the explanation, the privacy impact assessments, consulting my office, making sure that you develop these reflexes, that privacy is a priority. It's not something that you do after the fact and you're designing and you're thinking. You need to think about innovation, absolutely. But they're not mutually exclusive. When I was appointed, I said privacy is a fundamental right, but also it's not an obstacle to innovation. It's not an obstacle to the public interest. We can have both. Canadians deserve to have both. And tools like this will help organizations get it right. And my office will be there to help organizations get it right, in particular small and medium enterprises.
Thank you.
Great, thank you.
Thank you, MP Gaillard. MP Viss.
Thank you, Mr. Chair, and thank you to the witnesses. Last time I spoke to you, I brought forward a motion to get some of the answers as to why the government presented a broken bill. And I think we got some results, and we're seeing some productivity now because some of that information's been provided, and I can see it's been very useful to you as well, Mr. Dufresne. So That's positive. Some of my colleagues already touched upon the changes that the minister has mentioned regarding Section 12 of the bill. I want to dig into that really quickly. But first off, as I understand it now, when this current form of the bill, which is broken, is amended, we're going to see a children's right to privacy defined in the bill. Is that correct?
Well, we are going to see we'll wait and see what's being done, but what is proposed is to recognize in the preamble the importance of protecting children's privacy. So that will be there.
Right.
And the proposal is in the section 12.
So we already know that it's going to be included in the preamble, but will a fundamental right to privacy, based on the information we've been provided, be defined in the text of the bill?
What I understand the minister to propose, based on his letter, is to amend the preamble to recognize privacy as a fundamental right and to amend Section 5 of the bill to recognize that privacy is a fundamental right in the purpose provision of the Act, which is stronger than the preamble.
Good.
Federal Court of Appeals said. In terms of children, it's a similar approach, as I understand it. Recognize the importance of protecting privacy of children in the preamble, but also in Section 12. What Section 12 is the appropriate purposes provision.
Right. So can we properly amend Section 12 of the bill without having a clear definition of what a minor is and what constitutes a child in this legislation as well? Do we need those provisions to be amended before we can look properly at making changes to Section 12?
Well, the issue of the definition of what is a minor is, I know that the question was asked in earlier meetings, and that is something that could be included in an amendment, perhaps with reference to the provincial rules.
I'm sorry, I'll leave a little bit of time. Would it be your recommendation that we define a minor in this legislation to provide greater certainty for the protection of children when it comes to their privacy rights?
Well, I would support that to make it more, to remove uncertainty. I think if you're not saying anything, the presumption to me would be that you use provincial ages of majority, but I don't see a harm in specifying it here.
Thank you. That's very helpful. Going through the Library of Parliament provided us with a comparative document, and one of the areas they talked about was concepts of consent. In the context of children, can express consent really be provided when a child decides to download an app on their parent's iPhone?
Well, again, this is all part of the requirements in terms of the manner in which consent is provided, what will constitute valid express consent. So we've provided guidance on this. This is part of the guidance that my office can provide, but certainly children's consent has to be looked at differently. Okay, so would you recommend that we define clearly, so there's no confusion, that the purpose of that the concept of consent is defined twice in this bill, one for adults and one for minors, if we decide to amend this bill to include a definition of minors? I'd have to look at the specific wording of what's being proposed, but certainly... Well, we might be relying on you to provide that wording, sir. Right. So happy to provide suggestions on that if it assists the committee. Right now, the way it is done is that it recognizes minors' information as sensitive, and then it uses sensitivity as a factor in a number of those things, including consent. Right, but again, why I believe these definitions are so important, because the definition of sensitivity, again, can be muddled if we don't have those clear definitions of what a child is in the first place, according to this legislation. I think the same concerns I have about concepts of consent could apply to concepts of erasure in the bill as well. Can a child, if a child agrees to, if there is a concept of express consent for a child, do we really need, how would that relate to erasure or the right to have data removed? Well, the concept in the data removal for children in this instance is that you may have consented to something as a child, as a minor, and there's provision for obtaining parental consent unless you're able to do it as a minor. But as an adult, you may come to the conclusion that, well, I no longer consent. Thank you. Let me just, on that first point. Okay, so let's put this in context.
Mr. Turnbull talked about his daughter and apps. I have children in the similar age category, same concerns. We've heard a lot of cases, like in British Columbia, we heard about Amanda Todd. A young woman took her life and she exposed herself on the internet out of shame. So imagine there's a young girl, she exposes herself onto some type of app or platform, and that app or platform is not providing the right to have that information removed quickly enough when she was a minor. Does this bill go far enough to ensure that minors' rights are protected in cases of severe sensitivity, as I just outlined?
The bill provides for the minor, once an adult, to have that removed, and it
But not as a child.
As a minor as well. There's proposal. Minors' information doesn't fall under the exception that exists if there's a retention policy. So there's greater protection to remove minors' information, and that's something that the bill will do.
Without a doubt, if that situation arises, do you believe that this legislation is strong enough to address those very vulnerable situations?
I believe that the bill sets out strong disposal protections for information of minors, and it will also be interpreted as such by my office because of the sensitivity being a factor that I have to consider.
Do you believe under this proposed legislation that you have enough powers to go after that third-party app that may be retaining sensitive information about a vulnerable child?
What I don't have right now is the ability to right now recommend or let alone issue a fine in that situation, because Section 12 is not part of the offenses.
Is it your recommendation to this committee that we give you the power as the privacy commissioner to issue fines quickly and resolutely in cases where children's rights and their vulnerability have been challenged or have been exposed, or you get what I mean?
My office has to be able to act quickly, so all the tools.
So right now
should be
you can
available.
act quickly if you wanted to.
Right now, not for fines, and so that's why the ability to have compliance agreement that would include financial considerations, to have purpose violations as eligible for fines, and to adopt the tribunal situation so that it doesn't add delay to the process.
We don't want any delay, do we?
Delay is not desirable in the context.
It's your
of
belief that a
violations.
tribunal will delay your ability or the ability of people to have sensitive information wiped from the internet?
My view is that adding a level of review to the process will add a delay and cost, and so I've given two options to solve
Right.
that.
So in certain cases, if we go with the tribunal route, that sensitive information for a child could be delayed in being removed from the internet if we go under this the governance model currently suggested in the legislation.
Well, I'm talking about this in the context of financial penalties. I will have under this bill the ability to issue orders, and so there would be no delay to the order part. So I can order an organization to stop a practice and to stop a collection. So
in other jurisdictions, do privacy commissioners have the ability to lay criminal charges in the cases where the vulnerable or sensitive information related to children is in question?
Criminal charges is not something that would be laid by a commissioner here or elsewhere. It would be done by the police, but
Can
there
a
are
commissioner recommend to a relative police force to make those charges?
There are provisions there where we can notify the authorities in that context. And one of my recommendations, in fact, is to amend the period of time for summary charges, which is right now for 12 months. I'm recommending that that be longer or that there be an extension possibility because I don't want individuals to run out of time in case the process takes longer.
Well, that's a good recommendation. Thank you.
Thank you, Mr. Viss. Mr. Van Bynen.
Thank you, Mr. Chair. I'm finding these conversations very informative. In your 2018-2019 annual report, you made reference to having the authority to provide proactive inspection powers without grounds. My concern is the good guys we don't need to worry about. It's the bad guys we need to be able to act quickly against. What advantages for the OPC, what would be the advantages of having proactive powers rather than having to give an organization reasonable notice before performing an audit and when the CPA is possibly already being contravened?
Well, the recommendation on audits was one that was made for proactivity. It was this notion that with great power comes great responsibility, and so if you have authorities in cases where there maybe is an exception to consent for use of information, that there should be an ability, I think my predecessor referred to as looking under the hood, so having verifications, and that's what the audit process allows. And there were concerns with the criterion to initiate an audit, which I'm looking for the section in C27. My colleagues can point it to me. But it talked about at the time, and under existing legislation, that you have reasonable grounds to believe that the act has been violated, and there's a recognition that that was too strict. The current proposal in C27 now talks about has been violated or is likely to be violated, as I recall, and I'll be able to correct that section 97, where with reasonable notice and a reasonable time, audit the personal information if the commissioner has reasonable grounds to believe that the organization has contravened, is contravening, or is likely to contravene. So it's been improved in the proposal on C27. The test is not as reactive as it was before because of this notion of is likely to contravene.
I think that speed to the audit is critical, particularly when we are living in a digital world, and that can disappear very quickly. That leads to my next question. The fines that may be issued, what's the extent of the fines being proposed, in your opinion, given the scope and the scale of platforms today? Are the fines significant enough to have a meaningful impact? And what additional authorities would you have if my concern is that the fine may simply be considered a cost of doing business, and they retain the data and continue the violations. So could you clarify that, the scale of the fines?
Sure. And I think you heard this was an issue that came up with the Department of Officials. And I would agree with the departmental officials' answer to that question, which was that they are comparable and in some instances higher than our comparators in Europe in terms of the percentages. I'm looking for the sections. I think it's 4% of the turnover. So if it's a fine, it goes up to 10 million and 3% of the organization's gross global revenue. And if it's in terms of an offense, the percentages are higher. And so that's comparable to what we see internationally, but there is also the possibility of issuing orders. So I think that combination of those two tools is important and something to be monitored, but it's not standing out as being too small a percentage compared to international comparators.
Okay. And up until now, to what extent has obstruction been a problem for your department?
Well, we are, in terms of collaboration with my office, I think we treat with complaints case by case. And so we've seen situations where we're making orders and they're complied with, or not orders, we'll make a recommendation they're complied with, sometimes they're not. In terms of pure obstruction that would rise to the level of criminal offenses, I'm not aware of any. But it's something that has to be obviously dealt with in the legislation, so that there is a tool, there is a mechanism if that occurs. And so that ability, again, goes to the necessity to have enforcement authority. If you have right now only the ability to make recommendations, that is useful if the organization agrees and complies. But if they do not, then you don't have a remedy.
Good. I'd like to go back to an earlier question and I'm not sure if I got a specific response on that, but does the purpose of the Privacy Act place the rights of commercial interests on the same footing as personal?
Well, currently, if we look at Section 5, the purpose provision talks about the rules to govern the protection of personal information in a manner that recognizes the right of privacy of individuals with respect to their personal information and the need of organizations to collect, use, and so on. So that's why I was concerned from day one with the need to recognize privacy as a fundamental right, to send a message that, yes, you have to consider those two things, but these are not equal things. yes, you will do everything to have both innovation and privacy. And in most cases, I am convinced that you can have those things. Same with public interest. But if there's a clear conflict that you can't resolve, the fundamental right should prevail.
Do you have an issue with the word "and" in the purpose?
I think that putting in the preamble a recognition of privacy as a fundamental right, putting privacy as a fundamental right in this way with this amendment, I think clarifies the superior nature of the right that we're talking about, which is consistent with the treatment of it internationally and by the courts in Canada.
How much time do you have, Mr. Chair?
None, but I've been very generous with time with everyone, so if you want, you can.
Just one more question. We're talking about competition and scope and scale and concentration of resources. And the Act doesn't distinguish between small and large companies in terms of obligations. And so is there a risk there that this would be a competitive disadvantage for the obligations that are being placed on small businesses?
Right. Well, it's crucial to ensure that the regime can be met by small, medium enterprise. Absolutely. And the bill provides for a role for my office in terms of guidance. It provides the ability to join in certification programs and codes of practice. And it's something that has to be taken in consideration. So certainly something I'm very mindful of. Now, to the point on competition and privacy, this is an example where you can have overlap between competition and privacy. And we need to make sure that protecting privacy doesn't harm competition and vice versa. We've made recommendations to Parliament, to the Department on competition law review to make sure that you are dealing with what we call dark patterns, which are manipulative uses of language and of psychological tools to incite individuals to make wrong choices, either from a privacy or competition standpoint. This is why in the last few months, my colleagues, the Competition Commissioner and the CRTC Chair and we created a Digital Regulators Forum where we are working together to identify these areas of connection, interoperability. There's similar groups internationally. Our first focus right now in our first year is AI and making sure that we are on top of those new developments. But this is why one of my recommendations, my 15th recommendation, is to expand the scope of my office's ability to collaborate with regulators like these, in particular in the context of complaints. Because right now I can't do that with my Canadian colleagues. I can do it with my international colleagues.
Thank you. It's been very informative.
Merci, Monsieur le Maire.
Thank you, Mr. Chairman, and thank you again for your clear recommendations, and your testimony is helping with that clarity as well. I would like to just think ahead a little bit, because obviously this is part of the purpose of the bill. When we have quantum technology, how are we going to make sure that we protect Canadians and their data? We have to ensure that the legislation can maintain its effectiveness despite developments. We're talking a lot about generative AI right now, but in a year it will be more powerful. There may be other technologies. Maybe we will have other advances as well. So the principles need to be in place, and we aren't talking very specifically about specific technologies. The legislation has to be able to capture these advances and provides guidelines so that we can adapt. With respect to privacy impact assessments, we have to evaluate the risks. We have to be ahead of the developments. We need to be up to date. And one of the recommendations, therefore, that we have included is de-identification of data. I think it's a bit too broad, especially in the French wording. It has to be very clear, very forceful to be useful. In the definitions, we have to look at the risk of de-identification because more can be done with de-identified data. So we have to make sure that those definitions are very strict, and I think that we have to look at the risk of re-identification. If data is de-identified, then maybe in 2 or 3 years technology will exist that makes it clear who that information came from. So we have to take that approach. Thank you. Mr. Massey, please.
Thank you, Mr. Chair. Sorry about that. Just going back to with regards to the tribunal, if you mentioned it like an alternative, if we don't go with the tribunal, so what would be kind of the picture laid out from your design for that if we drop the tribunal altogether?
Sure. So that would be the model, in fact, that exists in Quebec and that exists internationally. In fact, I think the GDPR, when it is talking about the GDPR, as you know, the rule, the regulation applies to European Union. It states that the DPAs, they call DPAs, which would be the privacy commissioners, have the ability to issue fines. And in the recital, in the description of this, they're talking about the DPAs issuing the fines, and they're generally reviewed by courts. They list Estonia and Denmark as being exceptions where they have to ask courts to issue fines because of the specifics of their legal structure. In Quebec, the CAI, my counterpart in Quebec, has the ability to issue fines. They're reviewable by the normal court system. So if there was no tribunal, this could work in the same way, where C-27 now already, as drafted, creates a more formal process for my decisions. It provides that the investigations happen at the front end. You try to resolve matters. If you don't resolve the matter, then it goes to what is called an inquiry. And I will have obligations under the law to adapt codes of practice and consultation with industry. Procedural fairness has to be an element of that. And at the end of the day, those decisions, if you choose as a parliament to give the authority to my office to issue fines directly, those would be reviewable by the federal court through the normal judicial review process. So that's certainly an option. The other option, if the decision is to create a new tribunal, my recommendation is that then, if we're adding a layer of review, we should remove one, and so it should go straight to the Court of Appeal. Otherwise, there'll be costs.
If we create the tribunal, then that'll create a conflict with the Quebec model. Is that not correct?
With which model? I'm sorry, I didn't hear you.
If we create the tribunal, then that will create a conflict with the Quebec model. Is that not correct?
Well, it would be a different model. There'd be a situation, and we would have to manage that in practice because we do some joint investigations. As you know, we're doing currently a joint investigation on TikTok and ChatGPT. So I mean, and that's the case now because right now I don't have the authority to issue fines or orders. They do, and so that's something that we will need to manage.
Okay, thank you, Mr. Chair, and I suspect that's why we don't have the amendments in front of us.
Thank you very much, Mr. Massey. I'll now turn to Mr. Perkins.
Mr. Chair, and thank you, Commissioner. We had a discussion earlier about that the preamble has no legal binding stuff. It's a statement of intent. Once passed, it doesn't appear in the statute in Canada. So the purpose section is very important. And you've just said in response to other questions that if you put fundamental right in and the word and is there balancing against that's okay. It still makes fundamental right of prominence. But I'll go a different direction on that, saying let's assume that that's correct. But the Liberals are introducing into this bill a concept of in privacy protection, but the concept of legitimate interest, the legitimate interest of the business, the big business, and its legitimate interest to use one's data in a way that they don't have permission to use and allows them to even use it if it causes harm to the individual. So I would argue that Clause 18, which does this and introduces this concept, actually does not make the privacy of the individual of paramount importance. Clause 18 actually makes business interests more important because a large business can ignore whether or not you gave them permission and can ignore whether or not that information being used is going to harm you for their own legitimate interests, which are not always aligned with an individual. So would you not agree that having that and gives that power in Clause 18 much more weight for them to ignore whether or not it's a fundamental right?
Well, I've recommended a few things to address this in my 15 recommendation. In terms of the preamble, we did.
No, I don't want to talk about preamble.
Okay.
I just want to talk about this issue, and I don't have a lot of time.
Right. So I think that goes to the recommendation on making sure that the business activities are defined very carefully, and that they are all necessary, and that you remove the ability to make exceptions by regulations without showing that they're necessary, and the recommendation in terms of clarifying, highlighting the fundamental right has to be in the purpose clause, but it should also be in a preamble in the law, not just the bill, in the law itself, so that when people read it, they have it.
So that gives takes away the power to Parliament and leaves the judgment in the hands of bureaucrats as to what the list is, because that's where regulations get done. But I would also argue that the Liberals are further watering down this issue when you look at the terms of express consent in Clause 15. For those watching, express consent means I got to give you permission to use my data. But the Liberals have designed a number of escape clauses from express consent that allow businesses to get around it. And I want to talk about in Clause 18, but those escape clauses allow them to get around it, but also in 12.4, in the purposes of the bill, it says, where if a business needs to use a person's information for a new use, they don't have to get their permission. They just have to record it somewhere. There's no need for consent from the person if they use it for a new use. And as we know, this is evolving rapidly. I get somebody's consent 5 years ago. I decide to use their stuff in a different way. I just have to record it somewhere now. I don't even have to tell the person that I'm using it. So it's a further watering down of the person's protection as a fundamental right, giving much more power when you combine it with Clause 18, Clause 15, the exceptions, and 12.4. That's enormous power to business to do whatever they want with that individual's data without their permission.
I would say that Clause 14 talks about new purposes and indicate that they must not use it for a purpose other than the one determined and recorded unless the organization
But that's not what but that's not what 12.4 says. 12.4 says if the organization determines that the personal information it has collected is to be used or disclosed for a new purpose, the organization must record the new purpose before using it or disclosing it. It doesn't say it has to actually get express consent. That's in the appropriate purposes in an express consent section. It doesn't say that you have to go back for a new purpose and get express consent.
Well, and on those purposes, one of the recommendations that we've made is to make sure that the purposes be specific and explicit. So it's important for Canadians to know why is this going to be used, and when you're collecting this information, that Canadians have an understanding of what it's for and what it's not, and that this is something that they would be reasonably expecting. So we need to make sure that that is used in those ways.
So one last question. This deals with individual privacy, and there have been a lot of submissions already that ask about the ability to breach your privacy when you're put in a group data management, which is the way, as a former marketer, I deal with data from customers, is I put them into groups, customer segment, and then I pitch to you based on data, what's going on. Should there not be some provisions in here that limit the use of group data and the protection of personal privacy?
Well, you will no doubt hear views on that, and we've made recommendations on the predecessor bill in terms of inferences and treating inferences as personal information. I think that when you're talking about AI, we can see more and more ability to use information, maybe even de-identified information or anonymized information and then draw some conclusions about groups. So I think that is something certainly to think about and to consider. And those privacy impact assessments with AI, I think, become key to look at that aspect and to say, and again, this is why our definitions on de-identification and anonymization are strict. And not everyone agrees with that. Some have said it may be too strict, but it takes it outside the law.
Well, I met with many professors and computer folks who've told me actually there's no such thing as anonymized data. It's very easy to back out. But one last question. This puts more important responsibilities on your office, and the tribunal element probably puts more on as well. Have you done estimates about what this is going to cost in funding for your department to do this level of?
Yes, we have, and the amount we came was about almost a doubling of the current resources that we have. So we would need an additional $25 million per year to have the resources on the compliance side, certainly, but also on the proactive side, because the discussion we've been having, this provides responsibilities to approve codes of practice and certification programs, and maybe if there's a decision to have sandboxes. So all this advice to organization, SMEs, will need to be resourced. The new process will need to be more formalized, and the fact that there are more protection may well lead to more complaints and more judicial reviews and challenges, certainly at the front end.
Does that change if there isn't a tribunal as one of your options, or if you are given more authority to do compliance agreements with fines?
Well, the compliance agreements, I think, will help because it will mean that we can resolve matters. Again, it presumes that the organization will agree. A compliance agreement is a settlement agreement. So if the organization agrees to pay the amount, then we can resolve it. If the organization does not, then there still needs to be the process that will go forward. I think the tribunal will be resources that have to be dedicated to that if there's a tribunal to be created. If there isn't, part of that may have to be done by my office, but we'll certainly manage it as carefully as we can.
Thank you very much. I'll now turn to.
Right before I talking, huh?
I'll talk to Mr. Turnbull. The floor is yours.
Thanks, Commissioner. Really great conversation today. Really appreciate all the questions and the positive engagement here. I think this is really good for this work and this legislation. I wanted to get back to some kind of line of questioning that I started on. I didn't quite finish, but I sort of take it that C-27 and the minister's letter, which provides details, is introducing new obligations for organizations and companies. It's also giving your office and yourself new powers, which I think are both positive. One of the questions that keeps coming up for me when considering, what work you'll have ahead once we hopefully get this bill through and strengthened in many ways. I think, is there enough around detecting non-compliance? Because it seems to me that it must be hard to actually detect who is not complying with these additional obligations that are being introduced in C-27. Can you speak to how you'll undertake that? I know you've mentioned just with the last question there about additional resources needed, and I'm certain that that's part of it, but could you speak to how you'll detect the non-compliance when it does occur?
For sure. So certainly resource is part of it because there's a number of things here, whether it's audits, whether it's a certification program, whether it's guidance, whether it's communication, making sure that Canadians can flag things for us. Also the technological aspect to it. We have a technical lab at the OPC where we are trying to stay ahead of the evolving technology, and getting those resources and that expertise and that understanding will be important. Using all of those tools, using the compliance tool, the request for information, there are obligations in there where I can ask to see certain information of organization or the privacy management program. So certainly something that we'll need to put in place so that we are not in a reactive mode, but we are aware of what's going on. And I have to say, we have good engagements with representatives in industry and academia, and I think this will continue both in Canada and internationally to make sure that we are we are hearing of what the trends are, what the concerns are, and that we can act on them.
Just as a thought experiment, because, I'm sort of testing this in my mind, I'm sure there are cases of bad actors that are not forthright in fulfilling their obligations in certain instances. Will they go undetected within the current? So I guess what I'm asking is, do you have sufficient powers and tools to be able to really detect those nefarious activities where they may not, and intentionally not living up to the obligations, even once C-27 is passed?
Right. Well, we will continue to develop our technical abilities and our technical resources in terms of identifying things that we see in the ecosystem. The bill will provide more powers to obtain information, to initiate audits. There is an ability for my office to launch investigation. We call them commissioner-initiated investigation. That exists. That's what we've done in the context of our TikTok investigation, context of our ChatGPT. So we're going to continue to use all of the tools that we have. Legislation would provide some more proactive obligations on organizations to share their information. And in terms of bad actors, then we'll need to make sure that we're proactively able to identify them working with our colleagues.
Thank you. Does that whole process really only start? Do you start an investigation only when you get a complaint? Or how do you initiate or initially detect individuals or companies, in most cases, I think, not living up to their obligations? So currently, how do you do that? But also in the future, how do you envision doing that? Because I assume with additional obligations and additional powers, there's going to be a lot more activity to monitor, and we want that. I think this bill enables that and is designed in such a way as to empower you to do that. But I guess I'm just a little unclear as to what that process looks like.
Well, we do not require a complaint from an individual to launch a matter. So we have the ability to issue audits, we have the ability to issue commissioner-initiated complaint, and that can come from a variety of sources. It could come from monitoring of the media reports. It could come from monitoring of industry experts and actors who could flag things. We're going to continue to expand on these capabilities to do spot checks, to make sure about trends and concerns, but certainly this is something that needs to be proactive and not just reactive. We'll need to have the resources for it because, as you say, the environment is vast and there are a lot of resources outside of my office, including in organizations that we may need to be investigating. And so we need to have equivalent capabilities to do our work.
Yeah, I'm not trying to give you ammunition to ask for even more funds, but I suspect that there's a lot of online activity and a lot of data being collected, and I suspect that it would be very challenging to try and monitor and detect any breaches of the obligations that would be in C-27. So I think, with respect, I think you've got your work cut out for you in the future. I don't envy that, but I appreciate the work that will be undertaken. So maybe I'll leave it there for the moment on that. I do have another question or two. On the flip side of this, and I think Mr. Van Bynen, my colleague, asked some questions about this. What are the risks in sort of going too far? Are there any aspects, and by go too far, I mean, are there risks within this legislation and this debate that we're having where we could go a step or two too far and impede all of the positive benefits that Canadians are getting out of the use of these online tools? And the data that's collected is, in many ways, enhanced our lives in a lot of different ways. So there's a sense in which there's that balancing act between innovation and privacy, which you've already talked about. Yep. But I guess I want to know specifically, do you see any risks of going too far? Because we really have been talking from the other side, is like not going far enough on privacy rights. If we go too far, we might also stifle innovation. Would you agree with that? And are there any risks of that?
Well, we have to strike the balance, but we have to remember that we are dealing with a fundamental right. And so we need to start with that premise. We need to make sure that we're protecting the fundamental right to privacy because it's core to who we are as a society and as individuals. But absolutely, we need to do it in a way that supports innovation. We need to do it in a way that puts Canada in a competitive situation, that allows Canada to work and to trade on the world stage. And the good news is, in terms of protecting privacy, it actually gives us economic advantages in many ways, certainly in terms of Europe and adequacy and being recognized by that system as providing adequate levels of privacy protection. That's not just good for privacy, it's good for trade because it allows our companies to trade with Europe in a better way. So there are benefits there, but absolutely, we need to make sure you need to hear from industry. I've heard from industry. I have good dialogues with them. They may not always take the position that I do. That's okay. But I can tell you that we have regular discussions, regular exchanges, and they will be coming in front of you, and they have a valid perspective to bring.
They do, and I was sort of leading up to this, which is just interesting, and with very much respect, I say, as a privacy commissioner advocating for the fundamental right of privacy, it seems to me that you might naturally be inclined, let's say, to support one side of this debate. I can hear that you definitely appreciate the side of innovation and industry, which in a way is the minister's responsibility, that there also may be a flip side of this, that those industry stakeholders would express their positions with regards to where we could go just too far and limit the benefits that are also very important for this work. So I just wanted to put that out there, and I think respectfully, I hope that we can continue to have a very collaborative working relationship as we move forward, and I would expect nothing less because that's been the history so far in terms of our working relationship. So thank you very much for being here today, and with great respect, I really appreciate your testimony.
Thank you.
Merci beaucoup, Monsieur Turnbull. Merci beaucoup, Monsieur.
Thank you, Mr. Turnbull, and thank you very much, Mr. Dufresne and your team for coming again. It's not every day that we get applause for our witnesses, so that's a badge of honor. And now the meeting is adjourned. Thank you.